Hello, my name is Diane Dodds. I am an attorney from Kern County who has practiced in the estate planning and probate area. And for my community service, I put together a slideshow uh, that is designed to help people who cannot afford attorneys to do their own simplified or summary probate procedures. So let me tell you a couple of introductory things about the slideshow. The asterisks in the text mean that there are sample forms or additional information provided at the Law Library website under probate docs. And so I will refer to a lot of those in the presentation. So you'll want to go to that site so that you can download those forms. All judicial counsel forms are identified by form number, and all of these forms shown in the program can be completed online at www.courts.ca.gov/forms. So select probate and then find your form. Caution here, you need to download the form to your computer so you can save it and make changes later if you need to. If you just fill it out on the website, you're not going to be able to, it doesn't save easily and you'll probably lose it. So download it and then work from that. Pause. I also want to explain before we start that the summary probate procedures are set for statewide use, and they're in the probate code for California. So all 58 counties will use those same judicial counsel forms. The other forms, they will vary by county. The ones that I've told you, you can download from the Kern County Law Library website. But since the procedures are basically the same for all the counties, then you can use this slideshow even if you live in another county. You just need to be aware that there will be some details, of course, that will be different for your county. You will have a different probate referee because the state controller's office appoints probate referees. These are people who appraise property for probate purposes, and each county has a different set of probate referees. And of course, your Superior Court address will be different than the Kern County address. And your county's available methods for attending hearings by telephone or video conference will differ. So you want to be aware that each county in the court of the Superior Court, each county has separate local rules for probate matters, and you can look those up on your county's website to see if there's something special you need to do that you should be aware of that wouldn't be covered in my slideshow. Okay, so first question to ask is when someone dies, is it even necessary to have a probate procedure? Okay, probate procedures are not required where there's a beneficiary designation. For example, retirement accounts or life insurance. There, if you're named as a beneficiary, you just contact the company and they'll have a claim form for you to fill out. You'll supply a death certificate, and that's usually all there is to it. Probate procedures are also not necessary for assets that are held in joint tenancy. Okay, for accounts, that's usually John and or Mary Smith at the bank. And if it's listed in the bank records as joint tenancy, then you just have to present a death certificate to take the deceased person's name off that account. For real property, you will need to prepare an affidavit death of joint tenant. And this is one of the documents that you can download from the Kern County, a sample from the Kern County website. This is fairly easy to fill out, and you just fill in information about the deceased person, and you will attach a death certificate and then record that affidavit, and that will take the deceased person off the title of the real property. If your asset is a vehicle, a mobile home, or a boat, there are summary procedures that you can use that don't involve the court. You can go to the DMV for an affidavit for transfer without probate, for a car, a boat. You will go to the Department of Housing and Community Development for a certificate for transfer without probate for a mobile home. And then I have to say, this is only if the mobile home was registered with Housing and Community Development. Some mobile homes are considered attached to the ground, and they will be treated as part of the real property. And how you know the difference is if your mobile home has a decal and you have to renew it every year, and you have a Housing and Community Development registration card, then you go through Housing and Community Development. If your mobile home does not have any annual renewal of and a decal, then probably it's listed on your real property as an improvement. So you can look at your real property tax bill and you'll see that it will have some improvements there. And then you will need to use the procedures that I'm talking about in my class, because that will involve the court procedures. Okay, we have to know first who is going to inherit a deceased person's property. So that will go first. If they have a will, it'll go according to what the will says. In general, in California, a valid will has to be signed by 2 witnesses who watch the deceased sign. Or it has to be entirely in the handwriting of the decedent. And if you do not have a will, or your will doesn't qualify as valid, then the heirs are determined by statute. These are called the statutes of intestate succession, and all that means is succession that takes place when there is no will. You can also download some relationship charts that will show you how to determine the heirs if you are having an estate that's distributed according to intestate succession. In general, it's what you would think. Property is going to go to the nearest next of kin, right? So if I'm a single person and I leave children, then the property's going to go to my children. If one of my children died, but they had kids, then that share of the property goes to those grandkids. And this is all set out in those relationship charts. The only part that is sometimes confusing in California is that we are a community property state. And so it will differ somewhat how, without a will, a surviving spouse takes under the statutes. If it's community property, the surviving spouse takes 100%. If it's separate property, that's not the case. Separate property is usually property that was acquired before marriage or during marriage by gift. And if that's the case, if it's separate property, then it will differ according to how many children there are. For instance, if there's one spouse and one child, it'll go 50-50. If there are 2 or more children, then the spouse gets 1/3 and the children get 2/3. And the charts will, give the full situation if you're dealing with other relatives. Okay, there are special provisions that are only available to a surviving spouse or domestic partner. So if the only heir under the will or by intestate succession is a surviving spouse, then they can use either an affidavit death of spouse or spousal property petition. The affidavit death of spouse really only works if the property is stated to be community property on the deed, because otherwise title companies who issue the insurance for a transfer, they're going to worry that it was really separate property and there were other heirs. So only if it says right on it, it's community property, and that's not very common in deeds. But if you have that, then you will fill out an affidavit. It's very much like the affidavit death of joint tenant that we discussed before. It will have to have the notarized signature of the spouse, and you will have to attach a certified death certificate and then record this at your county recorder's office. The spousal property petition we'll get to towards the end. It's a court petition available just to spouses and domestic partners. If the heirs are other than the spouse, then there's 3 different summary procedures. First of all, for personal property, there's an affidavit for collection of personal property under Probate Code 13100. And the value limits for using this affidavit are set there on the screen. Depends when the person died. There's 3 different time periods. If it's before April 1, 2022, the ceiling is 166,250, and then it went up to 184,500 between 2022 and 2025. And if the decedent died after April 1, 2025, it's now 208,850. So this is very easy to use, and there is a form in the forms you can download from the law library that shows you how to do it. And you just need to give the information on the form and say who's inheriting it and attach the death certificate. And this is really a great deal because it will cover any bank account or any other kind of not land or buildings that is in the name of the decedent. And you now can go up to 208,850 to without having to do a full probate. If there is real property, okay, there are currently two available procedures. One is the affidavit real property of small value. And for that, all of the real property that the decedent owned had to be worth an amount within these limits according to the year that they died. If they died after April 1, 2025, it's now going to be $69,625. And in a minute, we'll go into the details of how to use this affidavit. And then the third procedure is petition to determine succession to primary residence. And they've changed the law just recently to allow a residence to pass without any probate up to, if the person died after April 1, 2025, up to $750,000. So that's a huge increase over what there was. You see, it was 184,500 if the decedent died between 2022 and March 31, 2025. So this will will open up a lot of transfers to the simplified procedure. There are, however, some glitches to it in my mind. It's that you cannot use the petition to determine succession to primary residence with an affidavit real property of small value. So if the decedent died owning a house that would qualify for the petition for primary residence, but they also owned a vacant lot, a mineral interest, it could be something of very small value, they are not allowed to use both of those together. So that means there would have to be a full probate proceeding and no summary proceeding would be available for that estate unless all the value of both the house, all the real property meets those low limits that apply to the affidavit of real property of small value. And not very many do because there are not very many houses worth under 60-some thousand. Okay, so the affidavit, I'm going to talk a little bit about each of these procedures. The affidavit for collection of personal property, there is, as I said, in the forms you can download, there's a sample form. You have to wait 40 days after the decedent died. You have to have the notarized signatures of all the heirs or the beneficiaries under the will. And a certified death certificate must be attached. In the form that I have at number 6, you just describe the property to be collected, like bank account number XYZ at Bank of America. And then on number 7, you list everybody who is inheriting a portion of that account. And all of the people inheriting have to sign that form and have their signature notarized. They don't all have to be together. You can send it in the mail, and the people who are out of state then could get notarized and send it back, okay? But you will need all the signatures notarized. So the affidavit real property of small value. Now, here again, all of the successors have to be available to sign. They don't have to be there. It can be mailed to them to sign. They don't have to be there at the same time. But they have to be alive and able to sign. So sometimes there's a problem because sometimes, say, grandpa died, and after his death, nobody got around to changing the title on a piece of property, and now one of the children has died. So now that child obviously is not available to sign the petition. So there's going to have to be different procedures at the different death levels, and it gets more complicated. The affidavit has to cover all of the decedent's interests in real property. So as I said before, if they have unimproved property, mineral interest, something like that, and a house, all of them together have to be within those limits. So how do you know if what your property is worth for purpose of these procedures? You need to prepare an inventory and appraisal. So if you're just starting out, that would be the first thing you would do with real property because you want to see which procedure you're eligible to use. Then when you get and this goes to the probate referee, I'll explain in a minute. You prepare the affidavit. Here you have to wait 6 months after death and then submit it to the Superior Court. It's really a bargain. It's only $45. And you don't have to go to a court hearing. It will be processed in the probate clerk's office. So it's by far the easiest procedure that we have going. And here is what the inventory and appraisal looks like. This is also our first judicial counsel form. And all the judicial counsel forms will be set up in a similar way regarding the heading. you'll see up at the top, you're going to put the names of all the people who are inheriting, oops, unless it's a huge group. And then you can put your name and then say comma et al, ETAL, which in Latin means and others. Or you could just say and others. And your address, telephone number, and where it says attorney for, just write in either there's a Latin phrase in pro per, in pro per, or you could just write in self-represented. Then you're going to put the address of your court, and this will vary according to, of course, what your county is. If the decedent died in Kern County, then it's, or the decedent owned property in California but died outside of California, then Kern County would be the place to go, and you would put County of Kern, and the street address is 21 College, Bakersfield 93305. Then you put the name of the estate. This is the name of the decedent. I advise, put their whole name the way it is on the death certificate. For instance, John Charles Smith. But if the deed to the property that you're trying to transfer, if it says Charles J. Smith, then I would put their whole name and then put AKA, also known as, and then put their name the way it is on the deed, okay? Or any other names that they went by in documents, okay? So you put their name and check the box decedent. Then in the little boxes in the middle, you're going to check the box final because you're saying this is it. This is all we have to collect from the deceased person. And then you're going to check the box, the last box, property tax certificate. And I'll explain that in a minute. You have to file a form with the assessor in your county, letting them know that the decedent died. Then if you're doing the affidavit real property of small value, there's no, you can't use this for personal property, only for real property. So there will be nothing in the first line. 1 will be 0, and then 2 will be filled in by the probate referee. All right. Then the middle, number 3, you're going to check all, because like I said, you've said this is all the property you have to collect. Skip number 4, and then property tax certificate, you're going to check the box B, have been satisfied. And this is because you're going to file a change in ownership statement, which is a BOE, stands for Board of Equalization, form that every county has when people die, to report the death to the county assessor. And so you're telling the court, the next line, under penalty of perjury, that you did that. So make sure when you check that box that you do follow through and file that form with the assessor. Then everybody who's inheriting has to sign this. If there's just 2 people inheriting, then you can squeeze them in, right? But any more, and you'll have to prepare a signature attachment page. And I would repeat this line, I declare under penalty of perjury, etc., and then have a space for the date, and then a line for their printed name, and then a line for the signature. You get to skip the part statement about the bond because no bond is required in the summary procedures. Okay, so these are written instructions to refer to that I just went over. Now that change in ownership statement, death of real property owner, it's a BOE 502D form, and you can get it online for Kern County this is how you would do it. But you can just go to the CA prop forms.org, and they'll have other, for another county, and you can find the ones for all the counties there. At the top, you insert the names of the heirs or beneficiaries who are inheriting the property. And, you're just going to pick one who would be the person for the assessor to mail notices to. You enter the name of the decedent, the date of death, you answer the questions yes or no, you enter the address of the property, and the APN, that's the assessor parcel number. And you don't have to fill out any other descriptive information if you have that assessor parcel number. You can find it on your property tax bill. And then where it says disposition of real property, you're going to check the appropriate box. And if you're using one of these procedures, it will be by court order. Okay, then you're going to explain who the property is being transferred to, and you're going to determine if you will need an additional form. There are some exclusions from reassessment. And if you qualify, then you will also want to file that form, and I'll explain more in a minute. If you had a trustee owning the property or inheriting the property, then you'll list the trustee's name and address. Then you list all the beneficiaries who are inheriting, their relationship, and the amount to which each is entitled. So this will be, a percentage. If only one person's inheriting, it'll be 100%. If, say, there were 2 children, but one died, leaving other children, then, the living child will be 50%, and then the grandchildren will be the other 50% divided into percentages. Okay, so leave everything else there blank or answer no unless it applies, and it only applies in rare cases. So only one heir beneficiary needs to sign and date under the certification. And for Kern County, you're going to mail it to the assessor's office at 1115 Truxton in Bakersfield. So whenever there is a person dies, there's a change of ownership in any real property that they owned, and the county assessor will reassess the property to current market value. So if the owner, the deceased person, had owned the property for a long time, that frequently the market value is going to be much higher than the assessed value because of old Proposition 13. The county's prevented from raising it more than 2% a year, no matter what the actual rate of inflation or appreciation has been. So generally speaking, if people qualify for an exclusion from reassessment, they'll want to get it because then they will get to pay a lower amount of real property taxes. Prior to Proposition 19 passing in 2020, there was a blanket exclusion from reassessment of property passing from parent to child or child to parent up to $1 million of assessed value, not even counting the principal residence. And then when the child had died, and there was also a grandparent-grandchild exclusion, which applies, but only in some cases. Well, after Prop 19, these exclusions were eliminated, except for if a residence or family farm is passing between parent and child or qualifying grandchild, and the qualifying heir is going to live there. So that is for all deaths which occurred on February 16th, 2021 or after. So if your decedent died on or before February 15, 2021, the older rules apply. then you will be able to get that big parent-child exclusion up to the $1 million of value, not counting the principal residence. And the forms you would use to apply for that exclusion are listed here. They're also available on the downloads in the Kern County Law Library. Well, if your death took place on or after February 16, 2021, then you are only going to qualify if the property being inherited is a residence or a family farm, and a qualifying family member moves in to live at the property within a year of the death. And that exclusion is only so good as long as they're living there. If they move out, then you lose that exemption. The forms to make a claim under these rules are BOE 19P and 19G. They're also available for download on the Kern County website, Law Library website. Okay, now to complete the inventory and appraisal, this will be attachment 2, and you type in the number 2 at the top. You're going to put the name of the decedent, okay? And here you're going to give a description of the property that the decedent had. So usually, say if this is an affidavit for real property of small value, it might be vacant lot uh, uh, located at 125 Magnolia Street, whatever town, and then described as, and after that, you're going to put the legal description, which is the description stated on the deed. It's either going to be a parcel number within a tract, or it's going to be an actual legal description of meets and bounds, like the northwest half of the southwest quarter of the whatever. So sometimes, in fact, very commonly, these descriptions are very long. So here's my advice on that. If the description is more than like 2 lines, I strongly advise you not to retype it on this form, because I've seen it happen numerous times. It's so easy to make a typing error and to have a mistake in your legal description, and then it will invalidate the whole transfer. So if it's more than a couple lines, just say, see Exhibit A, and then that you'll make an Exhibit A, which would just be a photocopy of the legal description that was in your deed. Not the whole deed, just the legal description is what you're going to photocopy. And sometimes, if it's a long description, the title company will already have done that in the past, and they'll have made their own Exhibit A with the complete description. So you can just copy that. That's fine. If not, you'll need to kind of cut and paste to make your legal description. If it is a residence, which is not commonly going to be on the affidavit, but we will need that later when if we're doing the petition to determine succession. I usually will describe it like this. For instance, a single family residence located at, put the street address, and described as, and then you put the whole legal description. It's always nice to have that, in my mind, street address in there. That saves a lot of confusion when you're looking at old deeds. Okay, so these are the written instructions for what I basically just said. So if you need to go back and refer to them, you can. Now, as I said, the state controller appoints probate referees for each county. And in Kern County, our referees are Michael Berger and Shane Normand. And you can just contact their office. Everything can be mailed to them. You don't have to go there. I tell people, if you think your property is kind of borderline, gee, maybe it's not going to go it's going to be right on the line between the maximum amount you can have. You may want to include a cover letter with any particular information that affects the value of your parcel. The probate referee is not paid a lot. It's like very slightly over 0.011%. So it's usually going to be less than $100, okay? And so they don't, especially if it's a house or whatever, they don't go inside. They don't even sometimes go around it. They just maybe drive by. What they're mainly going to rely on is the evidence in the recent sales that show what similar properties have sold for. So that's why it's very important if, say, the other properties in your neighborhood go for, a lot more money, and but yours is particularly run down, needs a new roof and a lot of repairs, then you could explain that to the probate referee. You can send photos by email to the probate referee, and I would, like I say, include a cover letter. This is only if you think you're, right on the edge of not qualifying for the limits. Okay, so here's what the form looks like. Affidavit, real property of small value. And this is the statewide judicial council form. So up here, we already went over how to do this. The main person whose address is being used for the heirs will put their name and their address, and their attorney you'll put improper or self-represented. You'll put the county and the street address of your superior court. And then you put the name of the decedent. The number one, it's pretty straightforward. You put the name of the decedent, the date of death, and where they died. And if you will recall, I said you have to wait 6 months after death to file this affidavit. So you have to show the court how it is that you qualify to use the county that you're in. So either the deceased was domiciled, meaning residing, they're having their permanent residence in the county at the time of death, and then you check box A if that were true, or you check box B if the decedent was not a resident in California at the time of death, but owned property in Kern County. So for instance, if you had property in Kern County, but your decedent had moved away and was living in LA County when he or she died, then you have to go through LA County, excuse me, court for this, not Kern County, even though this is where the property is. Okay, then you're telling the court that the gross value meets the limit that you have depending on when your deceased died. And you also are going to have to attach this form DE 300. It's just an informational form. You don't write anything on it, but you do need to attach it. And you can get it in the same, place you get the other judicial council forms. All right, then you get to the legal description and the APN. You are going to have to make an attachment for this, and you may have an attachment to the attachment, like that Exhibit A, if the description is really long. But you just want to make absolutely sure that it completely matches what you put on the inventory and appraisal. You can't just, you already are going to attach a copy of the inventory and appraisal So one might think that was enough, but no, you have to redo the description on this attachment 5, but be very careful that it matches. Then in B, you state what the decedent's interest in the property is. If they were the only owner, it's 100%. If somebody else already still owns a half or some other percentage, then you put what their percentage was. Then in 6, you answer if there was a guardian or conservator at the time of the decedent's death, then you put information about them and follow the directions. They have to get a copy of this. You attach the original inventory and appraisal as signed by all the people inheriting and the probate referee. And then under 8, you answer the questions whether there was any type of probate proceeding other than this form you're filling out being conducted in California. You check A if that's true. If not, you also check if that's true, then the representative in that full probate proceeding has to consent, and then you will have to attach the consent. This is not very common. Okay, so you get to the next page and you, of course, put the name of the decedent up there. And then 9 is kind of just information for you, pointing out that the people who are inheriting this property are liable for all the debts of the decedent that haven't been paid. Okay, so you're, of course, only liable up to the value that you received, but you are potentially open to creditors coming after you. That also does not happen very often because the values for this are so low. In number 10, then you're going to explain how the beneficiaries are entitled to inherit. Either they're A, check that box if you have a will and they're listed in the will. If there's no will, then you check box B, okay, and you're saying, we are the people listed in those probate code sections and those charts of intestate succession that I talked about earlier that have the right to inherit. Then everybody who's inheriting has to sign here. As you can see, there's only 2 places for signatures. So if there are more, then either you can create additional copies of this page or signature attachments. But there has to be a notary acknowledgement done for each person signing. So if maybe there's 2 people but they can't be together when they're signing, you're going to need 2 copies of that page or a signature attachment that will have the notary acknowledgement. Okay, so here is written down for you to go back and refer to, because this slideshow will be on the website and you can go and watch it again. Here are the written instructions. You will have to attach a copy of the will, if there is one, in addition to the inventory and appraisal and the certified copy of the death certificate. And here was where I'm talking about that additional attachment, DE 305, that you just have to print out and attach. You don't have to fill out anything on it. Okay, so filing this with the court is $45. And you have two choices. You can file by paper filing at the probate clerk's office or drop box or by mail, or you can e-file. And if you want to e-file, there's a small charge for it, but you can go online and then there are directions, and you have to pick a service provider and go through that service provider to file online. Oh, but I misspoke. For all the other procedures, you can e-file. You cannot e-file an affidavit real property of small value. It can only be done on paper. Sorry. Uh, it's one of the few exceptions. So when you get it back, it's like I said, you don't have to go to a court hearing. The probate clerk's office is going to process it. And when they have completed it and returned it to you, then you need to record it with the county recorder. You will need to prepare a cover sheet because the space that's on the form is not large enough for the county recorder. So I have sample form that you can download from the law library for the cover sheet. The reason why I do that is there is a special extra fees of $75 over the regular recording fees that they will charge unless you qualify for an exemption. And the most common exemption is that this was someone's home, like it was the decedent's residence. And so you will want to fill that out, and I have the little form block that you can use. You have to submit this to the recorder with another Board of Equalization form, an assessor form called a preliminary change of ownership report. And you can also download that form from the law library website. It's pretty straightforward. They just want to know who's inheriting it and who's going to be getting the future property tax bill. Okay, so now the final one except for spouses, is the petition to determine succession. Again, all of the people inheriting have to be available to sign. And first thing you do is prepare your inventory and appraisal, just the way we've gone through. Then you only have to wait 40 days after death to file this. But this does need to go before a judge. So you will submit it to the court, for Kern County, 2100 College Avenue. And the filing fee is $435. Now, if you're doing it in paper, that's how you would do it, okay? And I always say, if you're doing a paper filing, make 2 copies. You're going to send the court the original and an extra copy, and you keep a copy at home. So then you know what you did. If it got lost in the mail, you don't have to reinvent the wheel here. What the court will do is if you send in a self-addressed stamped envelope, they will stamp or endorse the separate copy that it's been received and mail it back to you. So then you know they got it, okay? If you cannot afford the filing fee, you can apply for a fee waiver, and the forms for doing that are also on the library website. Okay, this is what the form looks like. Now you see at the top, it's getting familiar. Fill it out the same way we've been filling them out. And so then we'll start with number 1. The petitioner, that is the person or persons who are inheriting the property. Okay, so you list all of them who are inheriting the property. and you put the decedent's name, the date of death, and the place where they died, city and state. And you're telling the court it's at least 40 days after the death. Then you identify the reason why you qualify to be in this county, which is either for A, decedent was a resident of the county, or B, decedent wasn't a resident of California, but owned property in the county. So check the box that applies. Then in 5, you'll check the box that applies. Did they die without a will? That's intestate, and you check that box. Or did they die with a will? That's called testate, and then you have to make a copy of the will and have it attached as attachment 5 or 12A. Now, the original of the will needs to be filed with the court. That will be a separate filing because they have a separate place that they keep wills called the received will. So you'll get a filing number for the will that's different than your case number for the petition. And the filing number will be RW whatever. I honestly am not sure of this. It used to be if you sent in everything at the same time, including your original will, then they would not charge you extra. But technically, and probably now they do, they are going to charge you $50 to file the received will. If you've already filed it or someone else has already filed it, then you want to use a copy of the will as filed because it will have that RW file number and it'll be easier for the court to look it up. So if there was, then, okay, now we covered whether they're intestate or a will. Then number 6, you have to tell them whether there's some kind of probate proceeding already started. And if there was a full probate open, then you have to have the consent of the representative and attach that. Then they ask about probate proceedings in other states. So you check the box, have not been commenced or have been commenced and whether completed, okay? And you give the state, county, court, and case number. And then number 8 is going over the property value limits. So you see they're much lower if the decedent died before April 1, 2025, and now they're much higher. So you will attach the inventory and appraisal, and then the next one, number 9 is you are going to fill in kind of family tree information, all right? Decedent is survived by, now you're going to check what applies. So a lot of these are either 1 or 2, spouse or no spouse. If it's no spouse, then you also will add information about either they're divorced or never married or the spouse is deceased. Then there was either a registered domestic partner or no registered domestic partner, just the same as the questions with the spouse. And if they did have a no registered domestic partner, then you have to check that box. That'll be the more common, okay? Now, if the next box 5, just did they have children? So then you check that box, and usually the answer is always natural or adopted. There's very few, but occasionally there'll be a natural child that has been adopted by a third party. Then, or no child, okay? Then under 7, whether there is issue of a predeceased child. So that means, say, grandpa died and he had 3 kids, but one died before him. who had children. So then those children, those grandchildren would be called issue of a predeceased child. So you check whether there was or there wasn't, all right? And then in B, you check yes or no, is or is not survived by a stepchild or a foster child who would have been adopted but for a legal barrier. This is also somewhat rare because the legal barriers are, it's uncommon, but sometimes it can apply. But there has to be, they evidence that they would have adopted them except for a legal barrier. Okay, then this next page, you state of, and you list the decedent's name. And then number 10, you're only going to complete this if there was a spouse but no children, or there's no spouse and no children, like they issue descendants, no descendants. So unless you're in that situation, you just leave it blank, all right? If you meet that, if you have, say, the spouse survives, but there were no descendants, or there's no spouse and no descendants, then you check the first box that applies. Did the decedent list have a living parent? If not, then you go on to the next box. Did they have a living sibling or issue of a sibling, meaning niece or nephews? And if not, then you check the next box. Usually, you're going to stop before you get to the end, but you go as far as you have to describe. And then you're going to make an attachment 14 when we get down there that's going to include the names and addresses of all these people that you identified in 9 and 10. So the next question on the form is 11, and that wants you to have an attachment that contains the legal description, and that I don't think I mentioned this, which I should have, for the APN. That APN number has to be included in your inventory and appraisal, okay, at the very end below your legal description. And so it also has to be included on this attachment 11. And for the real property attachments for the affidavit of small value, you have to put the APN number on there too. Then 12, you're telling the court each petitioner is a successor of the decedent, which would mean how? Either A, under a will, and if there's a will, then you have to include a copy, or B, if there's no will, then that the statute of intestate succession applies. And under B, if you file this and include a copy of the will, all right, but that will, the original of that will has not been recorded in Kern County. Not recorded, has not been filed in the court. They're going to send this back because they want to know that the original will was filed with the court the way it's supposed to be. Number 13, the interest of each petitioner. So if there's 4 people who each are getting the same interest, 4 children, it would be 25%, 25%. If it's more complicated because maybe there's children, but then had been deceased children, so now there's grandchildren, or there's a piece of property that the spouse is getting a third of, and then the children are sharing 2/3. You'll have to figure out those percentages and then list them here. And, you don't have much room unless it's just 1 or 2 names. So if it's more, you will include an attachment 13. Then on 14, you're going to prepare attachment 14, and this will have the names, the relationship to a decedent, whether it's spouse, child, grandchild, friend, whatever it is, you will list their relationship and then their address. And you will need to do this for all the people that are the petitioners, the people inheriting, number one, and all the people listed in 9 and 10. Plus, if there's a will, you have to list all the people named in the will, all right? So, and so that all will be included in your attachment 14. Now, these, what is that for? This is so they can the court knows who should have been notified, because all these people have to be notified of the hearing on your matter. I'll get to that in a minute. So if there was a will, you have to include in number 15 the names and addresses of all the people listed as executor. Or you check the box, no executors named, or there is no will, okay? If there was a trust named to be a beneficiary in 16, then you check that and you have to give name and address of the people listed in the trust. And then in 17 is if the decedent was under a guardianship or a conservatorship at the time that they died, then you have to include the names and address of the guardian or conservator. And then to finish it off, you have to collect all those pages that you attached and count them. And then you fill in the number of pages that are attached. You can skip the line that says signature of attorney and just go down here to the bottom. And then each petitioner has to sign. So if there's more than two, then you'll have to create a signature attachment. And so keep in mind that then you would check that final little box, signatures of additional petitioners attached. All right. So here are the written instructions. Refer to them. Now, oh yeah, don't forget, if the decedent died on or after April 1, 2022, you have to also attach that Form DE 300 that just lists the values that are permitted to file. And you don't fill out anything, you just attach a copy of it. Okay, I think I told you why you were filling out that attachment 14. These are all the people who get to be notified. So this is a protection, right? It's like, what if somebody files a petition and they have a forged will, or they do it wrong and they completely leave out somebody who's entitled. So the procedure makes sure that all of the nearest kin get a notice of hearing, and everybody mentioned in a will gets a notice of hearing so they know what's going on. So if you are filing e-filing, you won't prepare this in the beginning. You'll wait till your matter is accepted for filing and a hearing date is set, and then you will fill this form out, okay? But for people who are paper filing, you will prepare this form at the beginning. Okay, so we know the heading will be just like we have discussed before. Then under number 1, notice is given that, and then where it says name, you put the name of all the people who are inheriting. Has filed a petition, etc., and then describe it as a petition to determine succession to residence. And you're going to leave the hearing date blank. You could fill in the department, just because there's only one in Kern County, which is J1. Okay. And then on the second page or the back side, you leave blank the clerk's certificate, and you leave blank for now the proof of service by mail in the middle, but you could go ahead and fill in all the names and addresses, and of course you will need attachment if there's very many that were identified in your attachment 14. So you file this, and then the court will set a hearing date, and they will, if you're doing paper filing and you filed it with that extra copy that I told you to, then you will get it back and the court will have stamped a hearing date for you. Then once you have the hearing date, then you have to have notice mailed to all the people that are entitled. But a party can't do it, meaning a person who is inheriting can't do it. So you have to find somebody who's not inheriting, another relative or a friend or your neighbor, or doesn't matter, okay, but it just can't be one of the people who are inheriting. And they have to mail all the notices, and they have to fill out this proof of service by mail, where they, give their name, they give their address, and they explain how they mailed it. Okay, either depositing it in a sealed envelope with prepaid postage with the postal service, or placing it for collection, place where that's, like your business and you have a place you can put it where it will be taken out for mail. It has to be, you have to fill in the date mailed and then the place where it was mailed. Now they have a box 5. I served with the notice of hearing a copy of the petition. This is actually optional, but I find it's helpful if you do include the copy of the petition, because a lot of times the people who are receiving this, they don't know why they're receiving it, and the copy of the petition will explain a lot. Then the person who is signing this declares under penalty of perjury that they mailed the copy, at least of the notice of hearing, to all the people that were listed, and they date it, have a typed or printed name, and then they sign. And then if you're paper filing, the original of this proof of service has to be filed with the court more than 2 days before the hearing date. But you won't want to mess around and wait. You will have a lot of time because hearing dates are usually set very far in advance. So as soon as the mailing's done, file that proof of service so that you don't forget. Okay, here are the written instructions for future reference. I think I said the filing fee is $435. You can apply for a fee waiver, and that's another form that you can download from the library website. Now you're going to prepare for your hearing. Okay, start checking online at the court website, kern.courts.ca.gov. And if you click on the non-criminal case information and you select Smart Search, then you can enter your case number, no dashes or spaces. And you have to create a free account, but it's, free, so it shouldn't be a problem to use this search feature. Then your case name should pop up, and if you click on it, then the whole docket showing all the filings should be displayed. So this is useful for checking to see if everything you thought you filed with the court, they're showing was filed. Also, before the hearing, I would start checking about 2 weeks before and look for tentative rulings or probate notes. that would be entered at the bottom of the docket. On and off, they have had a probate notes tab also on the website that you could click, but sometimes they don't have that. And if not, it just appears on the docket. So 10 days, 2 weeks before the hearing, start checking. If the notes say ready for hearing, that means that the probate examiner, which probate examiners are attorneys hired that work for the court, and they review all the pleadings for the judge before the hearing. So if the probate examiner found it ready to go for the judge, they'll say ready for hearing. And then you just need to come to your hearing and prepare your order. Okay, if it says not ready for hearing, then they will have what are called probate notes. So they will list whatever they have found incorrect or missing, or they want further information on. And if that's the case, you will have to file a supplement. And so that's the reason why I say start checking, around 2 weeks before the hearing, because you want time to prepare and file a supplement if that will be necessary. Now, sometimes you can check and it won't be there. Sometimes the probate examiners get really, really busy and they can't file till right before the hearing. If that happens and you need to do a supplement and there wasn't time, because supplement would have to be on file at least 2 full business days before the hearing for the examiner to be able to review it. And if there just isn't time, then that's okay. You just show up at your hearing and say, oh, I saw the notes, but there wasn't time to file a supplement, and the court will give you another hearing date. So if you do have to file a supplement, I did this, there's no standard form for a supplement. You have to, make up your own form. But I made one for you. So there is a sample in the things that can be downloaded from Kern County, the website, and you will start with that. I did it in Word so that you can, it's already formatted and everything. So if you do need to file the supplement, you just, start with the form language and the heading and everything the way it is on the form. And then you just go exactly according to the numbers of the notes that the probate examiner put on the file. So if number 1 was, I don't know, number X not filled out, then you answer that and say, oh, inadvertently didn't fill that out. This is how it should be filled out. And so you will correct whatever errors or supply missing information. And all you need to do is follow the format of the number 1, number 2, number 3, whatever the notes were. So make sure you enter your case number and hearing date and the time of the hearing to the right of the main caption in the form. So let's say you go to the hearing and everything's taken care of and the judge is going to grant it. Then you are the judge makes the ruling, but you are the one who prepares the order for the judge. Okay. So if you are going in person to court and it was pre-approved by the probate examiner, then you can go ahead and prepare the order and bring it with you and then give it to the bailiff who will take it up to the judge. If not, if you were appearing remotely, then you just need to prepare the order and file it with the court. Or if you're e-filing, e-file the order. And if you're paper filing, send it to the court with a self-addressed stamped envelope and an extra copy so they can send it back to you so you'll know when the court officially granted your petition. Okay, if you are attending in person in Kern County, you should arrive early because there's not much parking and the courtroom's really small. So they encourage you not to bring a lot of family or friends because there's just not room. So, but there is an audio feed that family and friends can access on the court website if they just want to listen. Okay, if you don't want to attend in person, you don't have to. You can attend online or by telephone. So now the court uses this court call conference procedure. So go to the court website, and then we showed you what to click on so you can find out the information for the remote hearings. And this will not make sense to you because it says juvenile hearings, but that's because the probate department courthouse and clerk's office is in the Juvenile Justice Center building. Okay, and they only have one courthouse, one courtroom. So that's why it's under juvenile hearings. So you navigate to it, and then this is just a sample, shows you how somebody filled it in. You will, when you click the link, you will put your name, you put your email address, and you put your case number, and then you submit. Okay, so if you follow these steps, but your device, maybe you're doing it on your smartphone and it's somehow not compatible with the court call video stream, it's not working, you can't get it to work, then you can use your telephone to dial in. And here's the number and the password. Okay, so here's what the order looks like. It's pretty straightforward. It's just going to basically be repeating all the information that you put on the petition, okay? So just make sure you fill it out carefully and you do your attachments. Usually the only attachment will be the property description. Although, well, you may have an attachment that it's the additional people who are inheriting, all right? So here are the written descriptions for filling out the order. You just make sure if you have attached, well, you probably will have attachments, that you check the box on the form that says, the very bottom, signature follows on last attachment. And if that's the case, then on the very last attachment, you have to make a space at the bottom and draw a signature line and a date line for the judicial officer to sign, okay? All right, so you can refer back to those instructions. And then when you, if you're paper filing and you sent in your extra copy in self-addressed stamped envelope, then you'll get it in your mail and you'll know when the court has granted the petition, signed the order. So then you need to request a certified copy. Certified copies are $40 plus 50 cents per page. And you will, when you get your certified copy back from the court, then, or you could go to the clerk's office and request it physically if you want to. Prepare the cover sheet the way I have told you for the affidavit, and you attach the cover sheet and record it at the recorder's office with your preliminary change of ownership report. Okay, then once it's recorded, whether you did the affidavit of real property of small value or you did the petition to determine succession, once it's recorded, that serves instead of your deed, and your job is done. Okay, the last thing we have to cover is the spousal procedure called the spousal or domestic partner property petition. And here's what that looks like. And it's a judicial counsel form, so you fill the heading out the same way. And then you check whether it's a spouse, surviving spouse, or a surviving domestic partner. Okay. And then you fill out the information, the petitioner's name. And then, depending on whether you are saying it's community property or separate property, that's how you're going to check box A and B. If it's separate property, or, well, either one, you're going to check A, because if it's separate property, then that's what you've checked. It's passing to you from the deceased spouse. If it's community property, then the deceased spouse half interest is passing to you under A. Okay. You then only check box B if it's community property, because that box says you're just asking the court to confirm that the spouse, the surviving spouse, already owned half of it. Usually there's no appointment of a probate referee, so you can skip C. One of the different things about the spousal property petition is you don't have to do an inventory and appraisal, and it covers property no matter the value. So it could be millions of dollars, and you can still use the spousal property petition if you want to. So under 2, you give information. The petitioner is the surviving spouse, or maybe the surviving spouse died and the petitioner is the representative from the spouse's estate, or it's the guardian or conservator of the spouse. Or it's not a spouse, it's a surviving domestic partner. So whatever it is, you fill out the status of the petitioner. You give the date of death in 3. In number 4, you also give the information of how you qualify to do this in your county. Either the decedent was a resident of this county or a non-resident of California with property in this county. And then you tell the court whether they had a will or not. No will, intestate. And then check the box testate for will, and then you'll have to attach a copy. Then you give the family tree, if there information, if there's a child, and then if there's no child, issue if there's issue of a predeceased child. Okay, so a descendant, not a child, like a grandchild. And then, and let me make clear what issue of has to be of a predeceased child. So the decedent could have died and had, 3 children, and maybe now that there were 9 grandchildren, but you would only list the grandchildren if their parent, who was the child of the deceased person, died. Okay, a predeceased child. Then you check the box whether the petitioner includes whether the decedent was survived by a stepchild or foster child who would have been inherited but for a legal barrier. Then number 6, you're only going to fill this out if there were no descendants of the person who died, all right? If there were, you don't fill out 6. If there were, then you just check the first box that applied. Did the decedent have a living parent? And you check that. And if they didn't have a parent living, their parents were both dead, then if they had a brother, sister, or a niece or nephew, you check the box B, and you're going to list all of those people in item 9. So you're telling the court you don't have to administer the estate in a full probate, because the petitioner is qualifying as a surviving spouse or domestic partner. Now, you have to write up an attachment 7. And this is going to explain to the court why this is property that is passing to or to be confirmed to the surviving spouse. And I give you a sample that you can use in the forms you can download from the law library, because in attachment 7, what you'll do is give the names of the parties, when they were married, when they acquired the property, how you know it was community property. Maybe it doesn't say community property on the deed. Maybe it just lists both of their names, but then you will explain it's community property because it was acquired after marriage using the community property earnings. And if it's separate property, then you explain how when it was acquired and how this it is all, like, say, under the will, all going to the surviving spouse, or the surviving spouse is the only heir. There were no children, say. In practice, I will just say what I have seen a lot is when people were married and they acquired property, sometimes one of the spouses, either they weren't available or to fill out information, or maybe their credit history had problems on it, but for some reason, only one spouse was able to qualify for the loan. And so when that happens, commonly what they do, the bank or loan company requires that the other spouse be taken off the title, and the title will just say deceased spouse, whatever his name or her name was, as his or her sole and separate property. So if it says that, then darn, it's going to be hard to say it was community property, even though it was acquired during marriage and from community property. So if that's the case, what you can try is one of two ways around this. One is, if all the children really consider it the surviving parent's property and they're fine with it going 100% to their mom or dad who survived, then they can sign an assignment of interest in estate to the surviving spouse. And I made a sample form for you that you can download from the Kern County Law Library site. Okay, what if all the children are not available or won't sign off? Then you could try to, and this will be up to the judicial officer, because technically it probably doesn't qualify in that the statute says that for it to be community property, there has to be a written agreement if it says otherwise on the deed. But you could argue that, well, it really was community property. They were married all these years. The only money they have was what they earned while they were married. And the only reason why both spouses weren't on the deed was because of not qualifying for a loan, and that this was just done for purposes of getting that financing, and then still try to argue to the court it was community property. Okay, so there's that. All that would appear in your attachment 7. Then you have an attachment 7A and 7B, depending. If it's community property, then you'll have 7A and 7B, because each description would describe 50% interest in the property. If it's separate property and it all comes from the deceased spouse to the surviving spouse, then you just need the 7A. And you will put the full legal description, the way it is on the deed, and the APN number. All right. All right. And so that would be 7 or 7B. If it's community property, then you are going to also, and it's the same exact description, right? The description from the D, but if it's community property, it would just be 50% in 7A and 50% in 7B. And then you check the box whether there existed a written agreement between the spouses as to the status of the property. Usually this is not the case. And then number 9, this is where you list the name, relationship. Don't forget the relationship, like whether it's spouse, child, grandchild, whatever, age, and mailing address. So you're going to list this for all the people named in the decedent's will, if they had a will, okay, and all the people you checked in items 5 and 6 in terms of the family tree. Okay, then you would include, if there is a will, name and address of the executors. And if the will leaves property to a trust, then you're going to include a information about the trustee. So then you finally in 12, you're going to tell the court what, is there going to be a full probate? Sometimes they're done together. And so then you check the box A is being filed with this petition. Or if there already was a full probate pending, you check the date, fill this B out and put the date it was filed. And then if there wasn't a full probate filed and it's not being filed, then you check C. Okay, then you fill in the number of your pages attached, then your surviving spouse prints their name and, skip the attorney. The surviving spouse prints their name on the bottom and signs there. So there are the written instructions you can refer to. Oh, and that's now brought to mind something else I forgot. Always, if you have attachments and you're doing a paper filing, well, no, this is true whether e-filing or paper filing. You have to do an index. So you have the form, the judicial counsel form, the petition, and then you will create your own, type up your own little index that includes the name of the attachment, like usually it's a number like 7A, 7B, and then a description, well, it's 7A or 7B will be legal description, okay? And then the number of pages long it is, all right? And if you're paper filing and you send this in without an index, they will just send it right back. Okay, so the spousal property petition does have to have a hearing, just like the petition to determine succession. So I'm not going to go over that again. If you didn't listen to the part, you can go back to it. How to fill out the notice of hearing, and that you have to find someone other than the surviving spouse or the children who is going to do the mailing. And so there's the written instructions. And again, the filing fee is $435 unless you qualify for a fee waiver. You have to have somebody other than the surviving spouse mail the copy of the notice of hearing to all the persons who were listed. The notice has to be mailed. This is true of all notices of hearing. 15 days before the hearing is the minimum, not counting the day of the hearing. But here again, I wouldn't mess around so that you're not going to have a deadline problem. As soon as you find out when your hearing is, go ahead and have the notice sent, all right? And then the person who mailed the notice has to sign the proof of service, and that has to be filed at least 2 days before the hearing. So then you go to your hearing, just, according to the way I said, either you're going to, in the earlier part, either you're going to appear in person or you're going to appear by court call or phone. And let's say the judge, the probate examiner, you check ahead of time. If they have no problems with your petition, then you can bring the order with you if you're appearing in person. And you fill the order out, just the same as you filled out the petition, right? Same information. Just make sure you check all the applicable boxes and include an attachment that has the legal description, and then have a signature line for the judge where at the bottom of that legal description attachment. Okay, there are the written instructions. And the same instructions here for preparing for the hearing. Start checking online, see if there's probate examiner notes. If there are, then you will need to do a supplement. And then after the hearing, if you've been in person, you could have handed it in to the bailiff. If you didn't, you're going to send in an order. If you're paper, then include an extra copy in a self-addressed stamped envelope. After the copy is received, then you send in a request or go to the clerk's office and make a request for a certified copy, which is $40.50 per page. And then you're going to prepare a cover sheet, which is in your sample forms at the law library. And you attach the cover sheet and you take it to the recorder's office with a preliminary change of ownership report, another assessor form, and which is pretty straightforward, just information really on who the new owner is. And then you record that order, and when it's recorded, you're done. That's your deed, okay? Here are some general comments on submitting a will. The original does need to be lodged with the court. You can do it at the same time as you prepare your petition or affidavit, but it doesn't need to be done at the same time. You still will need to include a separate copy of it with your petition or your affidavit. If the witnesses to the will did not sign where they signed, if above it, it doesn't have language that says they're signing under penalty of perjury, then there's an additional form that needs to be filled out called a proof of subscribing witness that has to be submitted, where you contact one of the witnesses and they say, yes, I testify under penalty of perjury. That was the will that I witnessed. Okay. If the original will is handwritten, you will need an additional judicial counsel form called a proof of holographic instrument, which just means handwritten, and you will have to fill that out. Someone will have to type up the will, and then somebody is going to have to testify to that they recognize the handwriting of the decedent. So the general filing guidelines, where it says attorney for, you can insert in pro per or self-represented. And then here's, the address for our court in Kern County. Take care if you're from another county. When you put the name of the decedent, make sure you put it the same way on all the forms. Don't accidentally put it John Jack Smith one place and Johnny Jack Smith in another place or something. Okay, make sure it's the same. And that is the same for the heirs too, the petitioners. Their names need to be the same every place they're listed. So make sure the printed names are consistent and they match the signatures. All two-sided pages, if you're paper filing, should be tumbled or printed on separate pages. Tumbled means if you have a printer that prints on two sides, then you print upside down on the back side, but you totally do not need to do that if your printer does not equipped to manage that. You just print each page separately. All documents have to be two-hole punched at the bottom, and they have to be, held together with a staple or another means, and all attachments have to be labeled on the bottom with tabs on the originals, as if you're paper filing. So you can make the tabs yourself, just something that hangs down from the bottom of the paper and it's glued to the paper and says attachment 5A or whatever it is. And then here's the filing, the form numbers for the fee waiver if you need to file it. And if you're paper filing again, please submit everything with a copy and a self-addressed stamped envelope so you know it will be returned to you. Common pleading problems, you didn't check all the boxes you need to check, or your legal description and APN number doesn't exactly match on the inventory and appraisal and on your petition and order. Okay. Make sure, as I said, all names and signatures match. If a beneficiary now has a different name than the name in the will, you will list their current name, like Mary Smith, that's her married name, followed by AKA Mary Anderson, and that would be the name that was listed in the will. Be careful that Kern County is the right county for you to file. When heirs and beneficiaries are listed on an attachment, make sure you put the relationship and then you show the ages. If people are over 18, you can just put adult, all right? Don't go altering anything on the forms. Just include an attachment if you have to explain something else. And remember that these procedures have to cover all the interests in the property. You cannot file an affidavit for small property or a petition to determine succession unless all the heirs and beneficiaries are included and have signed. So if you have a family member that is having an argument with you or a dispute about something and won't cooperate, you're going to have to do a full probate. Okay, I am now come to the end.